Hearing in the appeal, Craig against the Majesty Advocate for the Government of the United States of America and another.
Can I perhaps mention before we begin, Mr. O'Neill, just in case it's helpful? Obviously, we've read the parties' written cases, and one point which it seems to us one issue of law which may be important, but isn't really dealt with to any significant extent, is if we're persuaded that the extradition of the appellant would not be in accordance with law, essentially because of abuse of power by the executive, so that regardless of the state of the domestic statute book, for convention purposes, it doesn't amount to action in accordance with law. We're wondering whether it's an answer to that effectively it would have made no difference if the appellant had been able to run a statutory forum defence. And effectively, is there such a thing as a technical breach of convention rights, or is it incumbent on the appellant to show that the failure to meet the appropriate standard of law, in inverted commas, actually prejudiced him? So I hope that's helpful, and you can deal with that point whenever it's convenient.
Well, I'll try to, but of course that is precisely what the other side are saying, and we're saying not. So I thought that point was already specifically focused. I say that it is in accordance with law point, and if it's not in accordance with law, and we've got the jurisprudence on that, then that's a breach of convention rights, and we don't go on to the issues of proportionality.
Yeah. Well, that seems to be
and I had thought that was clear from the cases, but
it's not really about proportion. I think we can all see that in accordance with law is an issue in itself.
Yes.
And if that test has failed, proportionality doesn't arise.
Absolutely.
But the question is it sufficient to meet that? Is it sufficient for it to be a breach of convention rights that effectively the law wasn't in the state that the rule of law required it to be? For example, would somebody who had no conceivable forum defence but was otherwise in the same position as the appellant be unextraditable on the law as it stood at the time when the appellant was dealt with?
Again, I had thought, and I will deal with this, but it is dealt with in the case, in the sense that we have said that there is no doubt that this appellant would constitute a victim for the purposes of this in the way that other appellants might not, because this appellant falls within the class which Parliament had intended should be able to pray and aid the forum bar provisions in a proper way, which he has not been able to do. So if there is concerns, and it's certainly that seems to be the main argument put against me, that, oh, well, it means that every extradition of the past 8 years in Scotland has been unlawful. That may or may not be the case. That's not something which I have to deal with. I have to deal with this appellant, and what I can say is that he is a victim. And there is in this case, there are so many counterfactuals and hypotheticals put across by the other side, and one of them is, well, what if it were somebody who had murdered another person abroad, planned it, committed it, and then suddenly, for whatever reason, rushed to Scotland and would have no forum bar, and therefore saying that on that argument, that hypothetical person would also be able to be freed of any claims against them of extradition. But it's a hypothetical. Yes. There are no such victims. They would arguably not be a victim because it never fell within the class of those that Parliament had intended. And so...
I just wanted to flag up that.
Yeah, no, it's, and I will deal with it in time, but... the
other matter is, it would be of interest to us to know whether there are other people who may conceivably be affected by the outcome of this appeal, or whether it's confined to this appellant.
Well, I'm getting instructions on that, but doubtless the Lord Advocate has it. My own understanding is that there are not. But the other point to be made, of course, is that the gravamen of our case, at some levels, it comes on the basis that this appellant brought a judicial review against the Advocate General and called the Lord Advocate, who declined to appear in the case, and got a court order in their favour. Now, I had assumed, frankly, when that was done, that there would be no, they would not proceed with extradition against this individual on the basis of that declarator until such time as they had changed the law. But that's not what was done. So the facts in this case are specific to this individual, relying on this court order, which had been specifically sought by them, and the extradition, notwithstanding that court order, proceeded. So we are, I see, squarely in the territory that was covered by this court in Majesty, which came out and is now reported, and there's a reported version in weekly law reports, in which the executive has blatantly refused to comply with and has acted incompatibly with a court order directed against it.
Yes. Obviously, Majesty may well be. It obviously is relevant. I should say not everybody on the court. Yeah,
I was aware of that, and I will be mentioning Majesty in more detail. But yes, there are facts which are specific to this case, specifically in relation to, in a sense, we've exhausted our remedies in the face of the unlawfulness on the part of the what we established was unlawful action on the part of the executive. But I hope I will deal more fully with both those points, which I had thought were dealt with in the case, but no doubt we can broaden out any issues which are of particular concern to the court. Of course, as I say, when I immediately mentioned the case of Majesty, which we will be coming back to, that this case is an important case and raises an important point of constitutional law to do with the rule of law, which is what the idea of the mutuality of respect, which is expected between the executive, the courts, and the legislature. And it's how the courts should properly and constitutionally respond when the executive has unlawfully refused to bring into force legislative provisions, which provisions were passed by the Union Parliament, the Westminster Parliament, with a view to increasing the rights of and the protections for individuals, and that this individual, this appellant, falls within that class because that's been established as a matter of fact before the sheriff, in that the substantial amount of the alleged crime was committed in Scotland. That's a matter of fact. That has not been challenged. So Parliament has passed has passed legislation which gives rights to and increases protections for individuals of the class of which the appellant is a member, precisely against executive action, seeking at the request of a foreign state their extradition from the United Kingdom to face criminal trials abroad. That's the big constitutional issue, which is focused on the facts of this case. And I can only deal with the facts of this case because at some levels this case has been bedevilled by the readiness or at the urging of the Lord Advocate and the Advocate General, for the court to engage in hypotheticals, which I say ultimately results not in binding and authoritative declarations of the law, but a series of obiter dicta. So the big constitutional issue is raised, but it is an extradition case, and one should not lose sight of that. And thankfully, my co-counsel, Mr. McIntosh QC, is an expert on extradition, so if the going gets tough, I'll turn to him on that. But our motion this morning is for this court to grant this appeal against the decision of the High Court of Justiciary below. By way of remedy, as set out in our case, we ask this court to find and declare, under reference to section 87(2) of the Extradition Act, that the appellant's extradition would be convention incompatible. And it would be convention incompatible because it results from an extradition procedure before the sheriff, which has been vitiated by the convention incompatible and hence ultra vires conduct of these proceedings by the Lord Advocate, and making that declaration then to discharge the appellant from this extradition.
Now, if a court does that, would it be open to the Lord Advocate to start all over again, and this time, under the legislation as it now stands, the appellant have the forum defence open to him?
Well, it'd be interesting if, again, in a sense, dealing with hypotheticals, if the Lord Advocate were to try, I would certainly say that that was constituted oppression. But I'll wait and see what Mr. McIntosh says as to the specifics, as to whether it would in fact be open as a matter of the statute. But I would, if there was no specific statutory prohibition, I would still say that it would be problematic in terms of having already, as it were, sold the assize of extradition. One of the issues, of course, in extradition is that it is neither criminal nor civil. And the Strasbourg court has said, as a result, extradition cases don't fall within the protections of Article 6. But of course, this court has held that when it comes to a UK national being extradited from the UK, there is a common law civil right to stay in one's own country, and that for the purposes of that, then one can say that Article 6 considerations of fairness can be prayed in aid, and the decision of this court in Pomikowski, which again we will look at shortly.
And the non-Scottish members of the court are to understand that when you refer to oppression, that's equivalent to the English doctrine of abuse of process.
Abuse of process, yes. And
when you talk about foaling your assize, that's the ne bis in idem concept.
I should be more aware of my Scotticisms, given that I practice the English bar as well. But yes, but this being a Scottish appeal, I'm sorry, I'm speaking in Scots. But I will be more aware of that. So that's the remedy, the declaration and the consequent discharge of the appellant from his extradition. In the alternative, however, as it were, on an esto case, and I don't even know how to say esto in English law, on the basis that I am wrong. Yeah.
It's your fallback argument.
My fallback argument. Too much ancient Latinism in Scots, I think. In the alternative, the esto case is that if the extradition proceedings have been conducted in accordance with law, or if there's some residual discretion on the part of the court, which frankly I don't see how the case law could say that there is, that notwithstanding it not being in accordance with law, it can still go ahead. If it is going ahead in any way, then this issue should be remitted back to the sheriff for the extradition sheriff's direct application in the context of a reconvened extradition hearing of the law as it now stands, which should be the forum bar provisions, properly and authoritatively determined, rather than hypothetically and arbitrarily determined, and also against that background, also to consider the full convention rights arguments. That would be the approach.
So speaking for myself, I haven't looked at the details of the commencement and provisions in relation to the forum bar provision. If one did that, if one remitted the issue back to the sheriff, would it be open to the sheriff to have a further hearing on the basis of the law as it now stands? Or does the law which applies to the extradition, is that fixed by reference to some particular event?
Well, one would be in a very odd situation, frankly, if the remit back to the sheriff meant that the extradition hearing were to be continued on the hypothesis or the wrongful basis that the forum bar was still not in force in Scotland, when it has been in force in Scotland. Certainly the commencement orders at number 5.
But it's not in force, is it today, in relation to this appellant's extradition? I mean, otherwise we wouldn't be here.
No, it hasn't been in force as at the date of the extradition. Yeah, that's the abuse of process. All that the commencement provisions say, which are at number 5 of the Primary Authorities Bundle, page 1113. Yeah, sorry. The commencement provisions say that Section 50 of and Schedule 22, and that is the foreign bar provisions, come into force for all remaining purposes on September the 17th of September 2021. So if it goes back to the sheriff applies the law as it stands. I would have thought it would be rather, I can't see any provision say that he should not do other than apply the law as it stands when the matter comes before the sheriff, because the sheriff is proceeding on the basis of his duties under the Extradition Act, which would be, as I've said, set out in tab 3 of the Court Authorities Bundle, where the sheriff has to consider, in particular...
Sorry, could you give us a page reference?
Page 1038 is where Section 87, at least, of the of what the sheriff does in terms of human rights. But the general provisions on the sheriff's powers and the like are set out at page 1026, section 77. Where it makes provision for an extradition hearing to be held before the sheriff. So if it's remitted back for an extradition hearing, the sheriff applies the law as it stands in that extradition hearing.
So can I just be clear, the provision bringing this into force from September 2021 is retrospective to the extent that it applies to facts before that date. Is that correct?
It doesn't state that it is otherwise limited. It doesn't state that it is otherwise limited, so it's not retrospective, because it's the sheriff. The decision is the sheriff has to take, at the time of the extradition hearing, a decision on whether the extradition of this person will be unlawful if it is carried out. It's all necessarily, in a sense, looking prospectively. So he is, or she might be determining what are the facts of the situation as they now are before the sheriff. That's why he hears evidence. Yep. He then applies the law as it stands. He certainly doesn't say, oh, well, originally your forum bar provisions weren't in force unlawfully, and therefore I cannot now apply those. And there is, and we would say anything other than that would be in abusive process or oppressive. There's some discussion of the idea of abuse of process within the context of extradition hearings in the decision of the Bow Street Magistrates Court, the government of the USA against Bow Street Magistrates Court, which is at number 9.
But you're not saying that remittal back would be oppressive, an abusive process?
No, this is we're still dealing with my alternative argument. I'm saying that if this court says that there has been or there is enough of there to be a valid process despite the unlawfulness, our primary argument is that there should be discharge on the basis of the unlawfulness. If this court says no, it has the matter has to be determined, then I say it has to be determined by the original extradition judge. That's what was done in the Norris case in 2009. There was a remittal back to the extradition judge in England and Wales on the basis that the House of Lords said it would not be appropriate for it to consider matters, given that it was an evidential hearing on matters as they now stood, and that it would also close off the other rights of appeal that would otherwise be open. So remission is what this court has done in previous like cases. And in any event, the as I said, the issue of the abuse of process as being a matter which can be prayed in aid in relation to extradition hearings has been established by a decision of the Divisional Court in 2006, then Chief Justice Lord Phillips and then Mr Justice Cresswell, which is... Yeah.
You're going to take us to that 2006 case?
Yes, I'm trying to. It's at tab 9, beginning at page 1166. And that dealt with a fresh request, so in a sense, a fresh extradition request that would have been made after the original request by the requesting state had been withdrawn. And in the meantime, the law had changed, and the issue was, specifically in that case, the issue was whether there should be disclosure of documentation.
I'm sorry, could you...
And in particular, paragraph 102, page 1194. And the issue was as to whether or not the the second extradition request was governed by the pre-existing law under the 1989 Act or was governed by the new law under the 2003 Act. And the court found that it was governed by the 2003 Act once it was back before, on the basis of the second request, before the extradition judge. Notes that at paragraph 102 and suggests that any other construction of the relevant commencement order would be bizarre, I think.
I see I think I found the answer to my question. I don't know if it's in the if we have this provision anywhere in the bundle, but if you look at the Crime and Courts Act of 2013, which you may not be able to do unless you do what I did and bring it up on Westlaw, and you go to Schedule 20, which contains these provisions, paragraph 7 says that in a case where the Part 1 warrant or the request for the person's extradition has been issued before the time when the amendments made by this part of this schedule come into force, those amendments apply to the extradition concerned only if at that time the judge has not yet decided all of the existing extradition bar questions. And that expression is then defined essentially to mean the issues that arose under the law prior to the amendment. So it rather looks as though even if we sent it back, even if we remitted it to the sheriff, he wouldn't be able to apply the new law because the relevant law was fixed at the time when either the Part 1 warrant or the request for the person's extradition was issued.
But of course, I mean, this is the eternal conundrum in this case. The fact is that when this was issued, the law was intended by Parliament to be one in which the forum bar provisions could have been.
Yes, quite.
So,
so the point I'm making is that remitting it for the exercise to be gone through again wouldn't get over that problem.
I'm sorry, my lord, I'm hearing too many things.
Well, the only point I was making was that it looks as though if the law to be applied is fixed by statute according to when the warrant or the request was issued, then sending the matter back now to the sheriff to be looked at again wouldn't solve the problem because he would be bound by statute to apply the old law.
Yes, but as I say, the conundrum on this is that one says one is bound by statute because the intention of Parliament was one be bound by whatever the relevant law was at the time. And we say it is clear because of this court decision that the intention of Parliament was that he should have had the forum bar provision. So at some levels, this is the constant issue in this case, is that we are trying to protect, or we are claiming the rights which Parliament, which we have established, that Parliament had intended we should be able to rely upon. We have not been able to rely on those. And it's not through any fault of our own. We have done everything by bringing the judicial review before the extradition proceedings to try and clarify and get out of this, as it were, situation of legal perplexity. But the creators of the legal perplexity have been the respondents.
Yeah.
It was the second respondents who refused, who failed to comply with the court order until weeks before this hearing. And presumably only because it was before this hearing and they didn't want to have to explain why. Well, they have to explain why they hadn't brought it into force, but they still have to explain why it took them 2 years to bring it into force after the court judgment. And the second reason for the legal perplexity is that the Lord Advocate, knowing that this individual had unlawfully been deprived of the right to rely on forum bar provisions, did not wait for the law to be changed. He had previously, or she had previously been, or her predecessors had previously been lobbying for the law not to be changed. But they didn't wait. They continued and attempted and sought extradition on the basis of an unlawfully defective statutory regime. That's why we're here. It's not for anything that we have done at some levels. It's because of the approach and the contempt, frankly, of the law, which has been shown by the other side.
Yeah.
But isn't the point that Lord Reid's effectively making that really you've got to put all your weight on your primary case, and that the fallback case has got something of a problem with it because we can't straightforwardly go back and ask the sheriff to apply effectively the new law, because that would be contrary to the way in which the new law has been framed.
But it's not new law. That's my point.
Right.
It's the law as in Parliament had intended would stand at the time of this extradition request for this appellant. That is not new law. Now, if there's a difficulty and a conundrum, it is in terms of how this court should, in a sense, get round that if it wants to go on the alternative remedy. But we've said it is an alternative remedy, but our primary remedy is that the executive bears the consequences of its failure to comply with the requirements of the law in this case, and the consequences are that we have to be discharged from this extradition.
The forum bar provisions were not the applicable substantive law at the time of the hearing before the sheriff.
Yes, it's astonishing, and in a sense one can get into I've complained about the other side making hypotheticals. What I see is that the law which was intended by Parliament to apply at the time.
It's different.
Of course it's different, that's why we're here. But the law, but if we are in a situation in where the executive is seeking consciously to enforce a regime which is contrary to the provisions which Parliament had intended to apply, there is a problem for the executive.
I understand that the point you're making, Mr. O'Neill, is a much broader one. But the point which my Lord has made, and my Lord Burrows as well, is that in terms of the substantive applicable law, it doesn't appear that you're going to be assisted if we were to remit this matter to the sheriff.
Yes, that may be the case, but I'm saying that if one applies, if one's concept of the law is one which is, and this is the bigger jurisprudential question, is that one which the executive has decided, contrary to Parliament's intention, should be applied. Now, if that's a notion of what the law is, there's a problem with the rule of law. That's why this case brings up these important points. And so, yes, is it beyond the ingenuity of this court to construct an alternative remedy that might deal with the concerns which have been expressed about floodgates and there's no real prejudice here. It may be beyond the ingenuity of the court. I'm simply setting out that the issue is not as simple as even simply saying, well, Schedule 20 of the 2013 Act says the law as it stands, precisely because the law as it stands is unlawfully standing.
Yeah. Now, the relevant date for determining the applicable law in this case, I think, is the date of a request, because this isn't a Part 1 case, it's a Part 2 case. So the date of a request, we have a request, well, we have a note of that at page 159 in the bundle, and it was the 15th of May 2017. So I think your argument has to be that by the 15th of May 2017, the law ought to have been, a commencement order ought to have been made in relation to Scotland, just as it had been in England in 2013.
Yes.
The failure to comply with the court's order promptly didn't make any difference, because if the court's order was made in 2018, even if it had been implemented the following day, the applicable law would still have been fixed as at the date of request.
Again, I'm not so sure about that, given that what is the effect of a court order? Classically, court orders state the law as it always has been. They don't have prospective effect.
Well, exactly. It's a declaratory order.
And this is what the law always has been.
Yes, but the only point I'm making is that although it is deplorable that it took so long, at least it seems, without having yet heard the response, at first sight it seems deplorable that it took so long to implement the order. But even if it had been implemented promptly, your position wouldn't have been any better, because your argument has to hinge on what the state of the law should have been when the request was received from the United States.
But again, I'm sorry that there is, and it's the subtlety of this. It's not the binary categories which is putting this is what the law is, and this is what the law ought to have been, some kind of Kantian divergence. We are here at some levels, because it's the constitutional point, is what did Parliament intend, and how was that intention thwarted? It was thwarted by executive action, which then seeks to rely on its own wrongdoing to prejudice the appellant in this case by proceeding against him without his having the benefit of being able directly to rely on the forum bar provisions which Parliament had intended that he have. The judicial review which was taken, and it was taken frankly in response to this, not in response, we see in June 2017 the certificate is issued. Thereafter, questions are raised in Parliament and answered in 2017, in December 2017, because it does seem rather odd that extradition is going ahead in Scotland in a situation where the forum bar provisions are not in force. The questions are asked in Parliament. In December 2017, the answer given is there is no intention ever to bring these into force in Scotland. This is a matter for the Scottish Government. Within 3 months of that, and remember this is a legally aided client, so we have to find the funding, but within the 3 months, a judicial review is taken, and that is and an order given in December 2018. But the effect of that order is declaratory. It doesn't say henceforth you are acting unlawfully. They were acting, it was an unlawful situation at the time, because what has happened is that there was a differential granting of rights in the rest of the UK and a denial of rights on the part of the Scottish Government and on the part of those resident in Scotland. And that was a situation which was being maintained by the United Kingdom Government up until September.
Yes. I mean, I think the main point perhaps is that because the provision fixing the applicable law by reference to the date of a request is in primary legislation, that couldn't have been altered by the Scottish ministers, or they could. I mean, they could, or they have power over. Or it's not the Scottish ministers, is it? It's the Secretary of State. But the Secretary of State couldn't alter that. So, at least as far as we've seen. And so all the Secretary of State could fix was the date as at which the primary legislation comes into force. But whatever date was chosen, the primary legislation was going to fix the applicable law as being determined by the date of a request.
Yes, but it's the commencement. That's what we're concerned about. Is the executive does have power and exercise the power by delaying the commencement, thereby doing contrary to what the intention of Parliament was, maintaining the applicable law in a manner which was contrary to Parliament's intention. So it is an executive. It is an executive action. Of course it is. It's squarely before the executive.
Yes. When I take that, they could have made the order, the commencement order, at the same time as they did for England and Wales.
They should have done. Absolutely.
In which case the applicable law fixed under the primary legislation would have included the forum provision.
As they should have done, as Lord Malcolm says that they should have done, so that precisely makes the point that the Schedule 20 applicable law was intended by Parliament to be the same in Scotland, England, but the differential change in that from 2013 onwards was contrary to Parliament's intention. And so it is the executive who are mucking about with the law, who are depriving, by their action and inaction, the rights which Parliament had intended this individual should be able to rely upon.
Can I say it would be helpful if we could have the 2013 Act added to our electronic papers, as obviously paragraph 7 is quite an important provision. Paragraph 7 of Schedule 20.
Yes. Yes, that will be done. But in a sense, if my primary remedy is accepted and the discharge is granted of this and only of this appellant in the circumstances of this case, then those fascinating jurisprudential questions of when is becomes ought in a sort of post-Humean way can be determined, but they don't need to be determined in this case if the primary remedy is granted. So, my Lords, I adopt formally the case which we have prepared for this. It's at tab 4, pages 74 to 123. But before I turn to that, I think it's important that we be clear as to what is actually agreed between the parties. There's quite a substantial and significant measure of agreement. And my reason for highlighting that is that because the other side have agreed so much, that brings upon it limitations upon which they can properly argue in this case. So, first of all, we've got a very full statement of facts and issues, and I know it's not normal or customary in this case in a sense, a statement of facts and issues are often a bit of a formality, but in this case...
Oh, they're vitally important from the court's point of view.
Yes, well, I'm glad to hear it. In this case, it is a fairly full statement of facts and issues. And so I just want to highlight a few points from that. First of all, and that's to be found at tab 3 of the bundle, the core volume bundle, page 53. First of all, paragraph 4.
If you could give us the... we only have... well, we have a few documents in paper, but almost everything is in electronic form.
I'm happy just to give the electronic page number if that speeds things up. Okay, we're at paragraph 4, electronic page number 54. Right.
Yep.
Before we go there, sorry, my learned co-counsel has told me that the 2013 Act, Schedule 20, paragraph 7, is in the bundle at page 1753.
Oh, thank you.
Yes, anyway, I was looking at page 54, electronic bundle, statements of facts and issues, paragraph 54. We note there, paragraph 4, page 54. We note there the appellant's a UK national. There's been an extradition request made in relation to accusations of securities fraud to do with the indictment from the Northern District of California avers that the appellant set up accounts in Twitter and tweeted false information, causing, it is said, prices of securities rapidly to decline, then saying causing losses that exceeded $1.6 million. Well, a decline in the share price doesn't necessarily cause losses unless they're realised, so it's not entirely clear as to the basis of that, but there it is, that's what the indictment says. But in any event, the indictment alleges it was part of a scheme to buy affected securities at a reduced price and thereby profit from it. It was a fraud. And then it is agreed that on the 5th of October, the appellant settled a parallel action taken by the US Securities and Exchange Commission in exchange for $97. And that represented by the US authorities' own accounts the profit gains from his alleged fraud. He also had to pay interest of $120, along with agreeing to an injunction against future violations.
Sorry, can I just try and, for my own purposes, see how you slot this case in accordance with the law's provisions? Okay? Mm-hmm. The first is that there should be a basis in domestic law for the interference, with the Article 8 interference. Okay? And I think you accept that the 2003 Act isn't invalid, and so the 2003 Act is the basis for the interference. But I understand you to say that part of the interference ought to have been in accordance with Section 83A, that is, with the bar, the forum bar. Okay. Is that the case that you're making?
No, it's more subtle than that, if I may say, which is that what I say, and I'm going to deal with this under reference to what is said, I say, by the Lord Advocate. What I say is that this was not in accordance with law because the extradition proceedings were prosecuted by the Lord Advocate on the basis of a defective statutory regime, which is to say a statutory regime which was contrary to that intended by Parliament because it did not have the forum bar provisions in it. So it's not a question of my saying, oh, well, there's a basis, which is, as it were, the salami slicing approach which the Lord Advocate puts forward as in the 2003 Act is valid, you don't say it's invalid, therefore there's a basis in law. One can't do that because the issue is as to whether or not the extradition proceedings which have resulting in ultimately the decision to extradite were in accordance with law. And I say you don't even get off the ground. There is no proper basis in law because the basis on which they were being conducted was consciously and knowingly on the basis of a defective statutory regime contrary to the intention of Parliament. But as I say, I'm going to develop that, hopefully. But staying with the statement of facts and issues for the moment. So, this is a crime which has been valued at profiting the appellant for less than $100. So, not exactly perhaps the crime of the century. It is not murder, which is the hypothetical which is put against me. It is a fraud, alleged fraud, from which a limited, very limited amount of monies was said to have been gained. The next point which is important is that parties are agreed at paragraph 5 that this case, in this case the Lord Advocate is acting under section 191 of the Extradition Act and is not acting in his capacity as head of the system of criminal prosecutions and investigation of deaths in Scotland. So all those issues are, and that is why we're before this court on a basis of a devolution issue rather than issues around compatibility issues, such as would be the way one gets to this court, other than by devolution issues from the High Court of Justiciary.
Yeah, and the practical importance of that is that it becomes a question of vires rather than, for example, under the Human Rights Act, the court would have a discretion whether to grant a remedy under Section 8.
Yes, very much so. And there's all that case law, the Judicial Committee of the Privy Council case law on that, and we've quoted that in the case of, it is very much, it's a question of the vires of the Lord Advocate. But the other important distinction, my Lord, is that, of course, it also means that the issue of remedy is a matter for this court. If it were a compatibility issue, the issue would be that one would remit back to the High Court of Justiciary for it to determine what remedy to give after the law had been clarified. Whereas because this is a devolution issue, then the matter of remedy is for this court, which is why I've suggested the two remedies of discharge and or remit to the Sheriff rather than remit to the High Court. The other important matter of agreement, at least I wish to highlight at this stage, is at paragraph 12, that notes that refers to the Baker Review. The Baker Review was set up to consider issues around aspects of the law of extradition, and in particular whether forum bar should be brought into force. We see that at paragraph 10 of the Statement of Facts and Issues. Paragraph 11, we see that the Crown Agent, on behalf of the Lord Advocate, made submissions to the Baker Review saying that the forum bar provisions should not be brought into force because the Lord Advocate saw it as a challenge to the Lord Advocate's traditional position as head of the prosecution service in Scotland in terms of his constitutional independence. Because again, one of the issues which has bedevilled this case, or which one has to bear in mind, is that the Lord Advocate is a person of, or an office which wears many hats. And those hats sometimes get confused, and the roles seem to become confused, as I say that has happened in this case, in that the Lord Advocate is appointed by the Union Parliament under the Extradition Act to carry out certain functions under the Extradition Act to prosecute extradition proceedings before a sheriff on behalf of foreign governments who've made a request. But the Lord Advocate also separately, or it being the same person, it's difficult to see how it can be separately, is head of the system of criminal prosecutions in Scotland. And of course the extradition provisions which have to be prosecuted by the Lord Advocate also make qua agent for the UK Executive under the Extradition Act also involve decisions of prosecutors, and the prosecutor in Scotland is the Lord Advocate. And so we have this immediate confusion of functions, and it's the confusion of functions that appears to have been behind the Lord Advocate's lobbying for the foreign bar provisions not to be brought into force, which is what the Baker Review concluded. They concluded, as we see at paragraph 12, that the foreign bar provisions should not be introduced into the UK because they consider that public prosecutors, rather than the courts, were best placed to make decisions about forum. But that recommendation was not accepted by the UK government. Again, that's a matter of agreement. Paragraph 12, page 57. And the reasons the UK government did not accept that recommendation was for the reasons set out by the Home Affairs Select Committee. So reasons set out by a parliamentary committee as to the importance of allowing for forum bar to be dealt with in open court. And those reasons are summarised at paragraph 33. So Parliament, or parliamentarians, have said that forum bar should be an issue which comes before the courts because it involves the fundamental principles of human rights, democracy and the rule of law, requiring that justice be seen to be done. The committee believes that it would be in the interest of justice for decisions about forum in cases where there is concurrent jurisdiction to be taken by a judge in open court, where the defendant will have an opportunity to put his case, rather than in private by prosecutors. Indeed, Parliament has already legislated for that to happen. The committee in 2012 is saying, therefore recommends that the government introduce forum bar as soon as possible. So this is a recognition by Parliament that the Baker Review recommendations should not be followed, that there needs to be a significant change in the course of extradition law. And in part, this court will recall that Parliament was responding to a certain public disquiet in what seemed to be the ease with which individuals were being extradited from this country, particularly to the United States. The case of, I think, Gary McKinnon comes to mind, whose ultimate extradition, although cleared by the courts, was then stopped by a decision of the then Prime Minister, Theresa May. So forum bar was brought in so that one didn't have to rely on political pressure from the executive as to whether or not one's extradition would be halted, but that the issues around whether or not matters could probably or could as easily or potentially be tried here without the need for extradition is a matter which could be determined by the court without coming into these political considerations. Sorry. So, Parliament has come in on this basis. The previous case law, pre-forum bar, at some levels emphasised as a strong issue in determining in favour of extradition the idea that it is important that extradition treaties be honoured by states. We've seen that from, as I say, the pre-forum bar decisions, among them Allah and the like, or Allah. And the reason for that is that the domestic courts are reflecting the positions which were being taken in the Strasbourg Court, because the claims against extradition were being presented in terms of causing a breach of convention rights, but the Strasbourg jurisprudence in terms of extradition causing a breach of convention rights was very much in favour of extradition. It was only in the most extreme or egregious cases that a finding of extradition, a finding of a breach of convention rights would arise from cases involving the deportation or extradition of individuals. For example, if they were to face torture, but otherwise if they were to face trial in another state, that was thought not in the generality to cause a breach of convention rights, on the basis that Strasbourg emphasised and gave a very strong weight to the interest in honouring international treaties. Now, you could understand that. It's an international court. It's based on states honouring international treaties. So from their point of view, of course, that is a very high interest and point of view. Forum bar changes that. Forum bar is specifically intended to weigh other considerations into account against the tendency simply to say there is a good in honouring extradition treaties, or we have a long established practice in our country of extraditing our own nationals, even if other European countries commonly don't, and so we're just continuing what we've always done. Forum bar is saying, no, we need a different perspective on that, and these issues have to be able to be raised before the courts, and they're set out in the provisions of section 83A.
I don't know if those other members of the bench may be perfectly familiar with this, but it might be helpful for them to see on page 981, I think the provision you're relying on, section 57(2) of the Scotland Act, that a member of the Scottish Government, which would include the Lord Advocate, has no power to do any act so far as the act is incompatible with any of the convention rights.
Yes, I mean
Which brought me on to the question about remedy, because my understanding is the function is the extradition function of the Lord Advocate, and you're saying that he's acting in contravention of convention rights.
Yes.
And therefore he's got no power to do so. So I was just wondering why there could be any other remedy but discharge.
Well, indeed, Perhaps I'm sorry I ever mentioned the possibility of an alternative remedy.
Well, I want to know what the basis of it was, that you were saying that there was a choice of remedies in this court.
I don't think there is a choice of remedy. That's why it was an ESTO basis. If you think I'm completely wrong, then, or you do not accept my submissions that the Lord Advocate has no power to act in the manner which is done, then it is still not an issue for this court to make its own determination on the appropriateness of extradition, and it would be a matter for remittal. But it's not what I want. What I want is discharge, for all the reasons which I've set out. So, yes, and it's a matter of agreement that Section 57.2 is the applicable provision in this case, and there is a lot of, and I'm not sure if your lordships want me to go through the Privy Council case law on this, but it is noted in full in the in the case, and footnoted the history of that. I'm advised there are no other pending cases which might be affected by this decision, other than. Yes, but there are no pending cases. There was another case which in which a judicial review was also taken, but he successfully opposed the extradition and was then convicted after trial in the Sheriff Court. So this is the only case. So let's not worry about murderers planning crimes and fleeing to Scotland. They don't exist. Let's not work on hypotheticals to scare the horses. It's this case which is important. So, another important concession or matter of agreement in the Statement of Facts issues at paragraph 15. Actually, paragraph 14 is useful. Paragraph 14 notes that when moving the forum bar provisions, an Under-Secretary of State before the House of Commons stated that because Scottish ministers and courts have a role in the process, we have decided that forum bar provisions should be commenced only with their consent. However, there was no provision in the bill that was passed as the Act which allowed for that, and that is a matter of agreement. They say at paragraph 15, no provision was made in the bill when passing through Parliament giving the Scottish ministers any form of veto over the introduction of the measures passed by Parliament and intended by it to cover Scotland as much as the rest of the UK. So we are agreed on that. That is not simply a matter of our submissions alone. Paragraph 18, the date of the forum bar provisions being brought into force is agreed as 14th October 2013. And paragraph 21, parties are agreed that because the forum bar provisions have not been brought into force in Scotland, it is not open to anyone resident in Scotland whose extradition to the US was requested by the UK authorities, It is not possible for them to rely on the forum bar provisions. Paragraph 24. It is agreed between the parties that the Lord Advocate gave certain evidence to a House of Lords Select Committee on the 16th of September 2014. Now that date's important because the Lord Advocate is giving evidence after the forum bar provisions have been passed by Parliament, after they have been commenced in the rest of the United Kingdom, in the knowledge that there was no provision in the Act giving the Scottish ministers any form of say over when or indeed whether the forum bar provisions should be commenced in Scotland, in the knowledge that also the Lord Advocate, when carrying out his extradition functions, was not acting in his role as prosecutor. That had been established beyond doubt. It made previous concessions to that effect, but it was established beyond doubt by the decision of this court in Capri against the Lord Advocate in the judgment of Lord Hope, paragraphs 14 to 23. And in the knowledge that because the Lord Advocate was not, when carrying out his extradition functions, acting as a role of prosecutor, this was not a function on which he could claim to have the constitutional independence which was otherwise guaranteed under and in terms of Section 48, subsection 5 of the Scotland Act. So that's the background. That's all that was known as at the 16th of September 2014. But on that date, the Lord Advocate says this: the provisions relating to forum bar brought into force under the 2013 Act will only be implemented in Scotland if the Scottish ministers request it. They have thus far not done so, and as far as I am aware, there is no intention to do so for the foreseeable future. Then goes on, this is consistent with the historic position in Scotland, where prosecutors are fully independent and have a fundamental discretion on whether to raise prosecutions or not, and with the independent role of the Lord Advocate guaranteed by Section 48(5) of the Scotland Act, heading that prosecution system. So, the claims which are being made by the Lord Advocate here to September 2014 are not well-founded. All that is being done is a repetition of the line that was put before the Baker Committee in 2011, the Baker Committee accepting the general proposition that prosecutors should be the ones left with forum bar decisions, which recommendation was not accepted by either the government or Parliament, and in fact legislated contrary to. So what seems to be the case here is in September 2014, a statement from the Lord Advocate that the Scottish ministers are seeking to defy the will and intent of the Union Parliament as set out in the 2013 Act. Parties are agreed that the UK government acquiesced in this stated intention from the Lord Advocate that Parliament's will should be defied, because, as we've seen, we then have this statement in 2017, paragraph 26, page 63, that the Minister of State at the Home Office says that the Scottish Government has decided that it does not wish Section 50 of the Crime and Courts Act to be commenced in full in Scotland, and there is no timetable for its commencement. This is a decision for the Scottish Government, and there have been no recent decisions on the issue. Now, it was that which clear and unequivocal statement after the enactment of the Act, after its commencement in the United Kingdom, and only in response to specific questions asked in Parliament that the judicial review was commenced, because it didn't seem to me to be a lawful approach, which is why the judicial review was commenced, taken, and was successful. Paragraph 27 sets out the detail of the judicial review having been commenced, and it is also a matter of agreement that the Lord Advocate was called separately for any interest he might have in the petition, but declined to enter appearance. Again, this is important. The judicial review petition called the Lord Advocate for such interest as he may have on three separate grounds, which were all specified in the judicial review petition. One, he was being called anyway as a Scottish minister. But separately, he was being called on the basis that he had functions under the Extradition Act. He was being called in his or the office's duties as defender of the general public interest. And he was also being called because the Lord Advocate himself or his office had made statements which apparently had resulted in this unlawful state of affairs. But he didn't turn up. The Scottish ministers turned up and they said, oh yes, we may have said things, but it was the UK government foolish enough to comply with our requests, but it's not our fault. We are legally blameless. We see this from the quotations from the pleadings in the judicial review proceedings, which are again a matter of agreement. Page 64, the UK government said that the UK government has not reached a policy decision not to bring the provisions of Section 50 into force in Scotland. That submission was rejected by the court. And it was also said the Secretary of State had regard to views of the Scottish ministers regarding the commencement, whereas the Scottish ministers said that they had expressed the view to the UK government that the foreign bar provisions should not be commenced in Scotland. In the context of a competence referred to the United Kingdom Parliament, that was a matter of the UK government whether or not to accept this view. The expression by the Scottish ministers of its position did not involve the exercise of any power on the part of the Scottish ministers. It had no legal effect. It is therefore a decision that is not subject to judicial review. But the fact is, it is a matter of agreement that this lobbying took place and that it was, in fact, apparently to protect some notion of the constitutional position of the Lord Advocate.
I think we can take it that the executive has behaved unlawfully here. I mean, we have a declaratory order which was never appealed against.
Absolutely. It's just that we sought an order also against the Scottish ministers on the basis of their inciting the unlawfulness and, as it turned out, or being part of a common enterprise of unlawfulness. And it was only the UK government that we got the declarator against. One of the points which is taken by the Advocate General is that, well, we didn't see, or we agreed. But the court records myself as agreeing that we didn't need a coercive order on the basis if a declarator was pronounced. And the Advocate General in this case seems to think that that's some kind of significant concession, as if there were a difference as a matter of the rule of law between a declaration of what the law is and an order by the court to the executive to comply with the law. I say that is certainly not a distinction which can properly in any way be upheld. So, and finally on the statement of facts and issues, it is agreed at paragraph 44 that the Scottish ministers decided to extradite the appellant following the procedure that we have here. Can I just, having mentioned what the Advocate General says, can we just turn to that case which is at tab 4 of the bundle, page 74 onwards. Oh, sorry, that's my case I'm referring to. It's actually in tab 6, page 150 onwards.
Electronic number, please.
Sorry?
Electronic.
Electronic number, page 150. 150. What? Right, is it or is it not? It is 150. Now, what the Advocate General says in his case at paragraph 12, page 152, is this, in relation to the judicial review we've just been looking at. In the judicial review, the lawfulness of the partial territorial effect of Section 50 was considered in the outer house of the Court of Session. The UK government maintained that partial territorial effect was permitted in terms of Section 61. The court disagreed and pronounced a declarator that the UK government was acting unlawfully in its continuing failure to bring into Scotland and enforce the foreign bar provisions. In the light of the declarator pronounced, and upon consideration of the policy issues arising, the UK government has brought into force the foreign bar provisions with effect from September 2021. So, from an order that was pronounced in December 2018, it takes 2 years and 10 months for anything to be done about it.
Mm-hmm. And that, I was mistaken in something I said to you earlier. That's critical because by the time anything was done, the procedure before the sheriff was over, whereas if it had been done promptly before the procedure before the sheriff had been completed, then the new provisions would have applied.
Yes, yes, indeed. But so, what are the consideration of the policy issues? Why does it take 2 years and 10 months to comply with the court's declarator?
Well, it might be said the policy issues have been decided by Parliament.
Indeed, there are no policy issues. What is the policy of the government? Is there some kind of policy as in we decide we don't have to obey decisions of a court because it's only an outer house judge, it's only the Court of Session, it's only Scotland? What are the policy issues? We're not told. We're told there are some, but something has stopped them from complying with this court order for 2 years and 10 months, which has caused prejudice to the appellant. And knowingly so, because it was the appellant that took the judicial review to try and protect his rights. And it was an 8-year delay between bringing these matters into force in the rest of the United Kingdom and bringing them into force in Scotland. Again, what are the policy issues? The only thing we've ever heard is that the Scottish Government didn't want them to do it, and they agreed with them, or they kept them happy. And the Scottish Government said, well, you know, they did, but we just asked them to. They didn't have to. And the Law and Advocate says, and I'm being told by Parliament under Section 193 that I have to conduct extradition proceedings. So it's not my fault that I'm carrying out the statutory duty on the basis of a defective statutory scheme, which is defective because I, as Lord Advocate, along with my fellow Scottish ministers, lobbied the UK Government to stop the implementation of these rights and protections in Scotland, contrary to the will of Parliament. There's something rotten, frankly, about that approach and that attitude towards the rule of law generally, but more specifically in the light of a court decision which unequivocally stated the law and on which none of them sought to appeal or to reclaim. Now, we can perhaps unpack from this case of the UK Government as to what they were thinking, as to what they think the effect is and importance of a declaration by a court as to what the law is. Paragraph 16 at page 153 says this, subparagraph 4. The court, so that's the Judicial Review Court, in the exercise of the common law, and then refers to Vince against the Prime Minister, and I'll take the court to that briefly, and in a manner that accords to the rule of law, rather than ordain implement, afforded to the Secretary of State a space to formulate a considered response to the declarator pronounced. The declarator said, you're acting unlawfully. What is the considered response to that? We know and will continue to act unlawfully. Because that's what the consideration meant for another 2 years and 10 months. A space to formulate a considered response. What space? There is no space in a polity governed by the rule of law for the executive to defy court orders and say, we need time to work out how to stop acting unlawfully, when the court has said clearly, commence the provisions. That's the unlawfulness, the failure to commence. You purge that continuing unlawfulness by bringing into force the provisions. But no, they've decided for a full 10 years, 2 years and 10 months thereafter to continue in their unlawful continuing act. And then this reference to Vince against the Prime Minister. Now, that is a case which is I suppose we might as well go to it briefly. It's at page 1800 of the electronic bundle, the supplementary authorities at volume 3, tab 30. That was a case which was brought in Scotland in response to the statements of the Prime Minister that he would die in a ditch rather than comply with the statutory duties imposed under what was then known as the Ben Act to request an extension to the Article 50 notice period. The constant briefing and public statements from the Prime Minister were to the effect that he would not, and his government would not, comply with that duty. However, when the lawfulness of this approach was challenged in Scotland by way of an application for specific implement of the statutory duty and by application to the court's nobile officium to, if necessary, authorise another person to make the request to seek an extension of the Article 50 notice period before the court, the counsel for the Prime Minister then said in their answers that actually the Prime Minister would comply with the law. And importantly, Lord Pentland says this, paragraph 44, in my opinion, the extrajudicial statements on which the petitioners rely must be understood in a political context. That is, expressions of the government's political policy that were clearly not intended to be taken as conclusive statements of the government's understanding of its legal obligations. Paragraph 15 of the answers, it's made clear that neither the policy of the government nor its actions in implementation of the policy necessitate non-compliance with the 2019 Ben Act. If I may put the point another way, the government accepts that in executing its political policy, it must comply with the 2019 Act. That being the government's clearly stated position before this court, there is no need for coercive orders against it or against the Prime Minister to be pronounced. The court should not pronounce coercive orders unless it has been established on the basis of cogent evidence that it is truly necessary for such orders to be granted. In my opinion, that has not been done in the present case. But importantly, paragraph 45, Lord Pentland then says, I would add only this, I approach matters on the basis that it would be destructive of one of the core principles of constitutional propriety and of mutual trust that is the bedrock of the relationship between the court and the Crown for the Prime Minister or the government to renege on what they have assured the court that the Prime Minister intends to do. The matter was appealed to the Inner House, which, and the decision there is to be found at page 1881. Commencing at 1878. But from 1881 onwards, the court, from paragraph 8, noted this, that on the material which was available to him, having quoted the passage of the core principles of constitutional propriety, just quoted, the Inner House continues, on the material available to him, the court agrees with the reasoning of the Lord Ordinary. At this stage, there's no basis for granting the orders sought by the petitioners in either process. Before coercive orders are granted, the court must be satisfied they are necessary, i.e. there are reasonable grounds for apprehending that a party will not comply with the statutory or relevant statutory or other legal obligation.
What was the page number again, Mr. O'Neill?
Page 1881.
Thank you very much.
It goes on then, paragraph 8. In this case, whether the Prime Minister will ever send a letter containing extension requests is uncertain. The UK Government and the European Union may reach a deal Parliament may approve a no-deal Brexit. If neither event occurs, it has not been disputed that the Prime Minister must send a letter. Until the time for sending the letter has passed, the Prime Minister has not acted unlawfully, whatever he or his officials may have said, privately or publicly. The existence of those statements are made in a political context. They don't give grounds for reasonable apprehension of future non-compliance. Paragraph 9, however, the quote goes on, the situation remains fluid. What is known that over the next 2 weeks, circumstances will inevitably change. The petitioners would be entitled to return to court and to seek an order ordaining the Prime Minister to comply with the terms of the 2019 Act as prescribed. And the court would consider authorising an official to sign a letter which the Prime Minister may have failed to do. So this is just, what this is saying is that coercive orders are very much the last resort and may be required in the face of contumacy of a court's order, but that the presumption will be that a declaration of the law will be sufficient for the executive to act in a manner in accordance with the law. And the important thing about this case also is that the court did not dismiss it. It said that it will continue consideration of the matter until such time as the time for the sending of the letter had passed, to make sure so as to allow the petitioners, if so advised, then to seek such remedies as might be necessary. As we said in our case, this is a shocking case. Vince was shocking enough, but this is more shocking, frankly, because we do have a clear statement of the law from the court in the judicial review petition, and no steps were taken to remedy that. And instead, proceedings were continued against the appellant. And that basic principle of trust that the executive will comply with the law was broken. And contrary to the Majesty case, which I've mentioned and we'll come on to, and of course the Evans decision, in which stated, and that's at page 2644 if we need it, subject to being overruled by a higher court or given parliamentary supremacy, a statute, or given parliamentary supremacy a statute, it is a basic principle that the decision of the court is binding as between the parties and cannot be ignored or set aside by anyone, including, indeed it may fairly be said, least of all by the executive. But the case of the Advocate General in this appeal ignores all that. And he says instead that a declarator leaves a space, not simply for a considered response, but then, if you go back to page 153, a space, in that space, the capacity for any party who would seek to rely on the provisions not commenced to seek to obtain an order in implement of the duty to commence if justified to their benefit. Now, I'm trying to unpack what's being said there, but I think what they're saying is that if you've got a problem, go back to court and seek an order for specific implement. But we don't have to do anything. We've got a space for our response to be considered. And in the meantime, unless and until the court orders us to obey the law, we don't have to. Now, as I said, that's a rather startling proposition, but it's what I'm taking from what's being said. But no doubt the Advocate General Counsel can explain just what he meant. As we know from provisions like Section 21 of the Crown Proceedings Act, the presumption of Parliament has always been that a declaration will be complied with by the executive, but it was not done in this case. Paragraph 17 then. The Advocate General concludes from this that the forum bar provisions at page 153, the forum bar provisions did not therefore remain unlawfully excluded from the statutory scheme as regards the appellant, but rather lawfully recognised as not part of the scheme, but on a basis that could be relied upon to bring them within the scheme if desired. Now, I'm having difficulty understanding what is meant by that, other than unless and until we get a coercive order against us, which we've disobeyed, then you have no rights to rely upon. So, as we've said before, the one particular word in paragraph 17 which really throws me is "if desired." On a basis that could be relied upon to bring them within the scheme if desired. Whose desire? The only person that can bring matters within the scheme is the United Kingdom government. We're suggesting there's a desire on their part not to comply with the law. We're suggesting that the court somehow has a power to bring these matters into force itself, exercising commencement powers. But all is obscure and lost to me on that. I've mentioned the Majesty case. I will now turn to that because, in a sense, it manages, or one would hope, cuts through these gnomic and, to me, incomprehensible pronouncements of what the executive's responsibilities are in the face of a court judgment by saying that there is an absolute obligation to comply with the court order, whatever form it may have, and that is a matter of the rule of law as an essential part of the rule of law, and failure to comply with the court order, whatever one's doubts, political or otherwise, is a breach of rule of law principles. Paragraph 19, though, well, first of all, paragraph 18 of the Advocate General's case, he says, when determining the issue of bars to appellant's extradition, the Sheriff, in not having regard to the foreign bar provisions, proceeded in accordance with the law. But it's in accordance with the law as warped and deformed by the Executive's inaction, because it's in accordance, it's contrary to Parliament's intention. So how that can be said to be in accordance with the law, again, escapes me. Paragraph 19 says, further, in any event, the approach of the Sheriff effected an elegant and appropriate approach to the consequences of the declarative in Craig. The consequence of the declarative in Craig is that the UK Executive is acting unlawfully, and the Lord Advocate is acting unlawfully by continuing with this scheme. That's the consequence. It's not for the Sheriff to afford an elegant and appropriate approach. It's for the Sheriff to draw out the consequences of that unlawful action. And paragraph 21(5), he says, the Sheriff's approach was a determination in accordance with law because it afforded to the appellant a consideration of the provisions not commenced, which would not otherwise be available to him, as if they were, to see if they would avail the appellant of a bar to extradition if they had been commenced, with a view to determining that their denial to him as a consequence of the unlawful failure to commence would render his extradition disproportionate in the light of the unlawfulness. Now, I'm sorry, this is supposed to be a case, a defence before this court. I mean, apart from its ungrammatical nature, its incomprehensibility, it seems to be frankly unconstitutional. The realms, the degrees to which one is said that this is in accordance with law because the Sheriff was engaging in all manner of hypotheses and taking a wholly hypothetical approach within the context of a proportionality challenge or proportionality balance, when we've already established that the issue of lawfulness is something which comes before any consideration of proportionality. So I'm sorry, I find this case really difficult and not in a good way, not in a way which makes me think, gosh, there are big legal questions I have to deal with here.
Can I go back to a big legal question that maybe does have to be dealt with? If one wanted to summarise the Strasbourg, I mean, we haven't looked at it, but if we wanted to summarise the Strasbourg case law about the in accordance with law requirement, I think what my stab at it would be that the domestic law must provide adequate safeguards against arbitrary interferences with convention rights. So the law has to be, well, first of all, the domestic law has to have been obeyed. The law itself has to be accessible and predictable, and it has to contain adequate safeguards. Now, there's obviously an issue about the first of those points, and the argument on your side would be that the executive has acted unlawfully here, plainly failed to comply with the court order within any reasonable period, and the consequence was to deprive the appellant of the opportunity to rely on Section 83A.
And also for the court to make an authoritative and binding pronouncement on the basis of the law. That law, because it's that authoritative and binding pronouncement that means whether or not his extradition or discharge of extradition is lawful.
Yeah. Now, the argument, when you look at the cases that have gone to Strasbourg from this jurisdiction, they've either been cases where there was no legal framework at all, like Malone, or they've been cases where the legal framework failed to provide adequate safeguards. And, yes. One can think of cases about the retention of DNA samples, fingerprints, and the like. And those cases have been brought, as the ones I can think of offhand anyway, have been brought by people who had committed either very minor offences or indeed no offence at all, but had been perhaps cautioned for stealing a bike when they were 11 years old, and they've still had criminal records, 40 years later. We haven't had a case where the complaint might have been made, for example, by a convicted rapist, that his DNA was being retained, and the argument in that situation being, well, the system of law, that it doesn't protect against arbitrariness, because if all I had done was steal a bike when I was 11, that I would be treated in exactly the same way. But the argument, the counter-argument to him would be, well, in any sane world, the police would be retaining your DNA because of the gravity of the offence that you committed. We've got the same sort of problem, same sort of issue here, that it's being said against you that, your complaints might well have substance if you were somebody who might have benefited from Section 83A, but since you weren't, there's in reality been no interference with your convention rights.
Well, I am going to do, and I'm very conscious that I've taken a lot of time. Because I was wondering, though, that given that the Advocate General now says he'll only need half an hour, I'm wondering whether I could steal that half hour.
I don't think so. You can steal from your reply time if you want to.
Okay, I'll do that then. I'll have nothing to say at the end. But I am conscious there are quite a few points which have been raised in that. One, the first point I make is that there are not degrees of human rights depending on whether how deserving one is, that somehow if you commit, that criminals don't have human rights. So, in terms of the example, as in, well, I just stole a bike as opposed to I'm a rapist, that's specifically in terms of the DNA retention, but we've got all sorts of cases. Abu Hamza, for example, issues about non-extradition in terms of committal of serious offences and the like, suing. These are, so you don't get more human rights because the more innocent you appear.
No. That's not the point I was seeking to make. The point was, can there effectively be a technical breach of the in accordance with law requirement, or is any? I mean, if this were a domestic administrative law case, the argument against you would be, well, it didn't actually affect the outcome. Can that short point be made against you in relation to the in accordance with law requirement?
It cannot, because one, the manner, this is not a technical breach. This is a contempt of the court by failing to obtemper, comply with the declaration. So it's not a technical breach. It is not an issue of general administrative law. We've got discretion here. Really, when you look at it, the consequences will be too much because this is an issue of various under Section 57(2) and as is stated in R against the Majesty's Advocate by Lord Roger, a decision which Your Lordship will be well familiar with, given that Your Lordship was the first instance in the case. He says, against the objections pronounced by, I think it was Lord Steyn, if this is to use a hammer rather than a scalpel, it's the tool which has been provided by Parliament in relation to these matters. And of course there was unease about the different approach between that which was unlawful and that which was ultra vires. And the case law of this court is absolutely clear that is a distinction. When it comes to Section 57(2), there is no power. That infects everything that follows thereafter, and there is therefore no discretion thinking, well, I was only a little bit pregnant, it was only a little bit unlawful. It's a little, if it's not in accordance with law, you don't have the power to do it. That's it. You don't have a little bit of power. You don't have the power. So that's the immediate answer to that in terms of the statutory background that we're working from.
And would that be so even if the forum bar point could do a particular defendant no good at all?
Well, as I keep on saying,
again,
once engaging in hypotheticals, all that we know is that this defendant fell into the class of those who were intended by Parliament to be able to pray in a forum bar and was not able to do so. That is a matter of agreement in the Statement of Facts and Issues. And in response to that, the court below then engage in contortions. And the interesting thing is, they say, oh, well, they have to do something to try and respond to the unlawfulness on the part of the executive by giving the executive a way out, by saying, oh, well, let's look, if hypothetically we were to apply this, and apart from anything else, they applied the wrong test wrongly, as we say, which is why we had if hypothetically we think for different reasons he wouldn't have been able to apply on it. So therefore, it's with one leap they're free. They get out of jail card. Okay, it's been totally unlawful, but this person can't rely on that unlawfulness. But that decision is not a binding decision. It's not authoritative in any sense at all. It's simple obiter dicta, and apart from anything else, it's wrong. The fact is that doesn't cure the unlawfulness. The unlawfulness is that he could not rely directly on the provisions, and that's a matter of agreement, that he could not do that. Now, the question is the court then to try and make allowances for the failure, the refusal by the executive to comply with its order? And I say, no, that would not be in accordance with the rule of law. It's not for the court to fall over and say, tickle my tummy or something of that sort. The court has to stand up for the rule of law here. And the consequences are in this case and in this case only. So you don't have to worry about floodgates or murderers fleeing to Scotland thinking, ha, I will now and never be extradited. In this case, what happened was that we took a judicial review to try and protect our rights. We thought we had done so, and we thought that an executive would comply with what the court had ordered and bring the provisions into force, thereby allowing us to rely on them. And the executive did not. Now, if that is not an egregious breach of the rule of law, nothing is. Nothing is at all. And it can never be suggested this is a mere technicality on the basis of hypothetical observations by a court which had never dealt with forum bar before. It was their first time because forum bar had never been 8 years of experience of it in England. They're fairly complicated provisions. But we get this impressionistic, hypothetical judgment because that's what the Lord Advocate asked them to do. Because that protects his or her position. But the rule of law is to protect individuals.
What's wrong with Lord Brodie's assessment at page 291, just at the end of that long paragraph, commencing with notwithstanding, that I can see that it can be argued that to apply those provisions of the Act which are enforced in Scotland without any regard to what Parliament must be taken to have intended in respect of forum bar might not be fully in accordance with law. However, before sending the case to the Scottish ministers in terms of section 87.3, the Sheriff has effectively afforded the requested person the protection that Parliament intended he should have. The first question is, was the appellant in effect afforded the protection?
And we've dealt with this in our case, and I'll refer, my Lord Stevens, to that, paragraphs 1313 to 1315, given the shortness of time, pages 114 to 116. The word effectively is taking all the work here, is doing all the work. The rule of law is not...
What protection was not afforded?
What was said, what Lord Brodie says, something very close to, the protection that was not afforded was that there could be no binding decision of the court as to the law on whether or not this person should be extradited or not, because it could not apply the forum bar provisions. All it could do on the Lord Advocate's approach would be to give a non-binding obiter opinion as to what they thought. Had the provisions been enforced, he might have been able to rely upon them.
Well, if the court had considered that there was a real prospect in this case of the forum bar plea succeeding, would it not have been open to the court then to say that his extradition to the United States would be inconsistent with his convention rights under Section 87?
But we've said that, of course, that it would be inconsistent because it's not in accordance with law. And the confusion which then comes in, which Lord Brodie does and the court below and the Sheriff, is that they say, oh, well, because, again, this is what the Lord Advocate says, in order to get round the fact is that what we're doing is unlawful, is you just weigh that unlawfulness into the balance of whether or not it's in breach of convention rights. And if... But what kind of weight do you give unlawfulness?
But it's not necessary to engage with a balancing exercise at that point. If the court were if the Sheriff had concluded that there was a real prospect of Mr. Craig succeeding on a forum bar defence, and that had been denied to him because of the history which you've related, in those circumstances, he could surely have said that his return to the United States would be inconsistent with his convention rights, and therefore should not happen because of Section 87.
But the convention rights, you follow what is required in terms of the relevant factors on assessing convention impact in terms of Article 8. And the forum bar provisions, for the most part, do not mirror those. They were brought in specifically because they gave greater protection than the convention rights. So what Lord Lloyd-Jones is suggesting...
You don't get to that point.
You have to if you're trying to pack it in, fold it into a decision on convention rights. It may be me. I don't understand it. It's the line that's been taken by the other side. But how is it, if, as is a matter of agreement between the parties following the decision in Love, where it is clear that the forum bar provisions add more than the convention rights arguments previously did, because they bring into account matters such as whether the trial can take place in the United Kingdom and the like. The whole series of matters under Section 83A. So Parliament is intending to increase the protections. Those protections have not been brought in, but somehow we're told that the Sheriff, in establishing a convention breach, can take into account that those factors which have been not brought into force for him to rely upon, which are not relevant to the convention because they're in addition to the convention considerations, have now to be taken into account to reach a judgment under Section 87 that this is in breach of the convention. Now, that strikes me as the Sheriff contorting too far, because the Sheriff is no longer carrying out the duties which are required of him by Parliament under Section 87, because he's bringing into a provision about assessment of convention rights issues which are not relevant to, which is questions of judgment as to how much weight to be given or the relevance of the various factors set out in 83A2 in terms of 83A3 in terms of forum bar.
Well, Mr. O'Neill, the difficulty I have at the moment is that it seems to me it could be said that the Sheriff was attempting to give the benefit to the defendant, the extraditee, of provisions which had not been brought into force, and did so by addressing the question whether there was any real prospect of the forum bar succeeding. But if he had come to the conclusion that there was a real prospect of that bar applying, had the provisions been brought into force, then surely it would not have been consistent with his convention rights.
He is not being given the benefit of the convention rights. Who is being given the benefit is that the Lord Advocate is being given the benefit in the sense that, notwithstanding the failure to bring into account the forum bar provisions, the Sheriff is being invited and engages in a wholly hypothetical exercise, which, having been done, then discounts completely the unlawfulness on the part of the Lord Advocate in bringing these provisions, and therefore orders, as happened in this case, the extradition of the Sheriff, of the appellant. One cannot get away from the fact that this process is tainted. And no matter, it's tainted from the very start, because the Lord Advocate is insisting on prosecuting it on the basis of a defective statutory regime. The Sheriff says it's really difficult. I'm having to do things, bring things in by the back door to try and get my way round the fact that the executive is acting unlawfully, but is doing it by the back door and trying to
forgive me, that's ascribing a bad motive to the Sheriff.
Oh, it's not. That's his words.
To express it in that way.
No, it's, I'm sorry, my lord. It's
the unfairness of the inapplicability of the bar, forum bar, is apparent. Sheriff was seeking to remedy that.
Paragraph 55 of the Sheriff's judgment at page 109 of our case. I reiterate that it is unsatisfactory that the court, in effect, has to apply Section 83A by the back door,
yes,
because no action has been taken by the United Kingdom Government in light of Lord Malcolm's declarator. Applying by the back door is not an applying in accordance with law. Well, that is my point.
That's a further point, but you ascribe a bad motive to the Sheriff by the way in which you
quoted. I'm sorry, I did not. I quoted what he said. I used the words he said.
Could you give me the page number for that reference? Sorry, again.
Page 109 of the case. It's quotation from the Sheriff's judgment.
And but as I understand it, your case is that the illegality is before you even get to the Sheriff. The illegality is of the so the illegality is of the Lord Advocate in proceeding when there was a breach of the law had taken.
The ultra-vires act of the Lord Advocate was in proceeding. Yes.
So the actions of the Sheriff couldn't remedy that.
No, because you've got an ultra-vires proceedings. It taints matters. the case law on this from the Privy Council in Miller against Dixon, among other things, following Stars against Ruxton in 1999. In Miller against Dixon, Stars against Ruxton held that temporary sheriffs who were appointed annually by the Lord Advocate, the precarity of their appointment was such that they could not be considered to be independent and impartial judges because matters were prosecuted before them by or in the name of the Lord Advocate. The result of that finding was, as the Privy Council upheld in Miller against Dixon, that all proceedings before temporary sheriffs were null and void, and it follows through. Now, I'm sorry, I could go on at length about the established devolution case law of the court, but that's where we're at on it.
If you look at it from the anterior, the earlier stage, it would be difficult to predict what the sheriff would do.
Well, the sheriff, no, it isn't. Again, we set out.
When you're looking at the concept of, in accordance with the law, being predictable and accessible. At that stage, you might have a little difficulty in understanding what the sheriff would do faced with this conundrum.
Well, the one thing one would expect is that he would comply with the law as it stood, rather than seek to remedy the failure of the person prosecuting the extradition proceedings to comply with the law. But I have set out again in my case at some length what the sheriff should have done, and that's at paragraphs at page 119 to 121, as to what a sheriff could properly have done rather than what he did in this case. And
O'Neill, can I just take you to Lady Dorian's judgment, electronic page 278, paragraph 28? Because as I understand it, what she was saying is that forum bar arguments, well, she says, are already arguments which could be and frequently have been advanced in submissions based on the existing legislation. So she was saying, irrespective of this, the forum bar provisions being brought into force, there was already a way in which many of these forum bar arguments could be put forward and frequently were put forward. I mean, what do you say to what she there said?
well, again, it's something we've dealt with expressly in our case at pages 110 through to 114. But it is not the case. As I've already said, it is clear from the decision in Love, and it is a matter of agreement from the Lord Advocate, that the forum bar provisions are adding something which was not there in the law before, are increasing the protections available, which were not available on the basis of convention rights arguments before. Now, what Lady Dorian is saying here wrongly is that they didn't make a difference, that Section 83A somehow can be, as again, folded into convention rights considerations. That is not what the law has been understood to be in England and Wales, and it is not the law as understood by Strasbourg or by Parliament, which specifically legislated for these provisions to be in addition to the existing relatively low standard of protection under reference to and only to convention rights. And it is interesting that what Lady Dorian actually says in paragraph 28, just as Lord Brodie uses the word effectively or something as good as or something close to the protections, she says forum bar should be elevated to a separate and formalised basis, as if it was simply a codification of the pre-existing case law rather than, in fact, an innovation to protect individuals' rights.
Just sort of focusing a bit more tightly on the relevant act of the Lord Advocate, if I'm following the argument, you would say that once the court had issued the the declarator that effectively the state of the statute book was the result of an unlawful failure by the executive to make the commencement order, you, I think, would say that when the Lord Advocate presented evidence to the sheriff at the hearing with a view to having the appropriate decision made by the sheriff, without the executive having yet responded or complied with, one should say, the declarator, you'd say that was the unlawful act.
Yes, I mean, your Lordship will recall the devolution case law was saying that the very calling of the case by the Lord Advocate before even leading any evidence.
Yeah, I wasn't using that sort of terminology because I'm not. Wasn't sure, I don't know. Do you call an extradition hearing? You do, right? So it's effectively like it's treated like a criminal hearing.
It's treated like summary proceedings and reliably informed in criminal cases.
So you say in calling the case rather than having it adjourned until the appropriate commencement order had been made, and thereby depriving the appellant of a statutory defence which, whether it was meritorious or not, ought to have been open to him, you say that that was effectively an abuse of power and contrary to Article 8.
Because it wasn't, because he was acting not in accordance with the law as required.
Yes, he was acting effectively not in accordance with a declaration made by the court.
Yes, absolutely. And as a result, and because it's a various limitation, it necessarily infects everything which the sheriff then attempts to do to get round that at the Lord Advocate's own instigation.
And you say that because he's effectively subverting the court's order. The order is made in proceedings brought by Mr. Craig in order to enable him to plead this defence.
Yes, absolutely so. Sorry, no, what's that say? No, what does that say?
Am I right in that so you're effectively saying it, there's a sort of double unlawfulness? There's not merely the executive's failure to comply with what Parliament has laid down. We're also talking about the judiciary's failure to comply the executive's failure to comply with a judicial order or a judicial declaration.
Yes.
In that sense, we're on a double issue of unlawfulness here, are we?
Yeah, absolutely, which is why I referred to the Majesty case, which I know that not everybody was involved in on this bench, but it is a recent decision of the case to the effect that it is an aspect of the rule of law that the executive has to obey court orders, and that's it. It's an absolute duty, whether or not they think they're valid or not, or whether a court of limited or unlimited jurisdiction. Whereas this, and the important point about the Majesty case is that it is a question of acting compatibly with the court order. So it doesn't need necessarily a breach of the court order. It's acting in a manner which is not compatible with what the court itself has done. So it is a broad enough principle to apply to the actions of the Lord Advocate in this case. And as I say, in accordance with the approach which was taken by this court or the Privy Council in Miller against Dixon, it is not a question of the unfairness or prejudice which might be suffered by the appellant. That was what was argued following the decision of the High Court of Justiciary in Stars Against Ruxton, which my Lord Reid was a member of the bench. It was said that, well, this is a mere technical failing. There is no suggestion that anybody did not in fact receive a fair trial in accordance with Article 6 by the fact that these temporary sheriffs were answerable to the Lord Advocate, and it's only, as it were, a theoretical issue, and nothing can be pointed to which shows there was any actual bias evinced. But that was rejected. That argument from the Solicitor General was rejected on the basis that the proceedings were vitiated ab initio by the Lord Advocate, calling a case before a judge who was not sufficiently convention independent and impartial. So it was nothing that what the judge had done wrong, it was what the Lord Advocate had done wrong, and the same applies here. The fact that the courts do their best, and I'm not saying it's in bad faith in any sense at all, so I'm sorry if my Lord Lloyd-Jones thinks that. They're doing their best to deal with an impossible situation in which they have been placed by the Lord Advocate. But it's a Gordian knot which is created as a result of out of all sorts of hypotheses and what-ifs and maybes. Whereas the way to cut through this simply is to grant a discharge that would be, as it were, just satisfaction that would remedy the breach of convention rights. If so advised, it is always open then to the United States, as happened in the Bow Street Magistrates Courts, to re-raise a new extradition request.
Just coming back to that, if you analyse it on the basis of the activities of the Lord Advocate at an anterior stage, calling the case on,
yes,
he's got no varies to act, interfering with a convention right, which is contrary to the rule of law.
Yes.
And therefore his actions are outside his powers.
Yes.
So the proceedings are, as it were, null. But why grant a discharge? Why not just declare that the proceedings were ineffective? Because
there is an outstanding extradition order against him as following on from those proceedings, and Section 87 requires the court, if there is a finding of a breach of convention rights, to grant a discharge. And there is a breach of convention rights because it is not what has been done.
That's a breach of convention rights by the court. That's not a breach of convention rights. My recollection of Section 87 was it is an obligation on the court rather than on the Advocate General. And here you're focusing on the Advocate General's breach of convention rights.
No, I'm focusing on the Lord Advocate's breach of convention.
The Lord Advocate, sorry.
And that's the point, is that you cannot make a distinction between the court and the Lord Advocate in proceedings in Scotland.
Section 87 can be found at what page?
It's in the core, it's in the primary authorities. Yeah. And it's at 1038. And it says, if a judge is required to proceed under this section by virtue of sections 84, 85 or 86, he must decide whether the person's extradition would be compatible with the convention rights within the meaning of the Human Rights Act. Person's extradition by the executive ultimately, because they make the order. And in this case, it would be an order resulting from a convention incompatible procedure, and one which, by virtue of section 57.2, was ultra vires Lord Advocate. And if the judge decides the question in the negative, he must order the person's discharge. So that's what we're saying follows on. That's why we seek discharge.
One short way through this might be to argue that the Lord Advocate was acting unlawfully and as a matter of domestic, administrative or constitutional law in proceeding with the extradition in the teeth of a court order declaring that the current state of a legislation was the result of an unlawful failure to make a commencement order. He could have been JR'd for doing for doing that, and if that's a good argument, then plainly the extradition wasn't in accordance with law.
I'm sorry, I'm not quite sure where the argument's going. We've exercised our statutory rights, so therefore you've got to do that before any GR can be run. If it attempted to do that, that would be...
Whether it's done in a J, but whether you actually take separate proceedings or not, I mean, the point would be, if you're trying to identify what is the basic unlawful act of the Lord Advocate here, it might be said to be proceeding with the extradition at a time when the court's declaratory order remained unimplemented.
Yes, but of course this court only has jurisdiction, the appellate jurisdiction, if the arguments to that effect are ones which can be presented in convention terms. As I said, the common law may not be an ossuary, but for the purposes of this court, we are this court's jurisdiction is restricted to what is convention, which is why it's done in terms of the convention principle of legality.
Is it open to us to find that in the breach? I mean, obviously, if it were a breach of domestic law, that would be also it would entail a breach of a convention.
Yes, absolutely so. But that's what was argued before the High Court and before the Sheriff, that what the Lord Advocate was doing was unlawful. However one characterises it, whether in convention terms or, but certainly if it were purely in domestic terms, that would be sufficient to be not in accordance with law, because there's never a proper basis in domestic law.
But if the Lord Advocate shouldn't have proceeded at all, it was outside his powers to do so, we never get to Section 87, do we? Because the judge wouldn't be required to proceed under this section.
Yeah.
I mean, wasn't that Lord Brodie's point? If you go this far, court wouldn't have had the power to discharge.
Yeah.
It wouldn't have, and the executive would not have had the power to order extradition as it did. So yes, that's what I mean about everything being tainted. And Majesty is an example.
What I'm saying is we can't then discharge under, or it's not up to us, is it now, to discharge under Section 87 on your argument?
Well, I mean, now we're getting into the Majesty decisions about the metaphysics of nullity, really, as to does null and void mean for all purposes, such as to mean that this court, which mean that this court has no jurisdiction either. So where do we all end up then? That none of this happened. It was all a dream. We've still got an extradition order outstanding against us. Something has to be done about that, and justice has to be done.
But the proceedings consequent on the proceedings before the Sheriff, consequent on the Lord Advocate's unlawful act, wouldn't be valid proceedings under the Act. And the consequence then would be, if the Lord Advocate still wanted to proceed with the extradition, now that the legislation has been amended, he can lawfully do so, but the Sheriff, the proceedings for the Sheriff, would be taking place validly now, after the amendment of the legislation, and so the new law would apply.
Yes, but the Lord Advocate chose to act unlawfully in this case, and seek the extradition on an unlawful basis. Yeah. The result of that is that he has breached convention rights, and the result of that is that this court has to order discharge. But in terms of the metaphysics of nullity, I suppose one gets a bit the problem in the Stars against Ruxton and Miller against Dixon cases was that everything which the temporary sheriffs did was unlawful because they were not independent and impartial judges. In this case, clearly there is an extradition sheriff. Clearly cases can come before that extradition sheriff, so in that sense has jurisdiction. But it's a question of the fact that the Lord Advocate seeks to persuade the sheriff to reach a finding in favour of his extradition, or in favour of that there are no bars to his extradition, in the face of a unlawfully defective statutory regime. That's what brings the virus, the infection of one, the Lord Advocate had no power to do that, and therefore the sheriff should have recognised that, and that's why we say in pages 119 to 121 precisely the steps which the sheriff should have taken. First of all, he required the evidence consider the evidence and reach a decision on two matters of fact, whether there was engagement with Article 8 and whether or not we fell within the class of persons whom forum bar was intended to protect, i.e. was a substantial measure of activity performed in the United Kingdom. The answer to that, those two questions are yes. We've got Article 8 interference, and as a matter of fact, he's in the class of those forum bars to protect. So, having decided that, and then found out that forum bar was not available to be pleaded or relied upon because it had the executive had unlawfully refused to bring it into force and unlawfully refused to comply or failed to comply with forum bar, the sheriff then, recognising that, would have said, well, that what you are now attempting to do is not in accordance with law. If what you're so you're attempting to get an order from the court interfering in convention rights, which is not in accordance with law. That is sufficient. It is a necessary finding on my part, therefore, that this extradition consequent upon these actions would be convention incompatible under Section 87.1. Therefore, I order your discharge under 87.2. That's what the sheriff should have done, could have done, but was misled by the Lord Advocate into engaging in hypotheticals and worrying about.
I thought you said that he shouldn't have proceeded at all because the actions of the Lord Advocate were outside his powers.
It was outside the Lord Advocate's power to act in a manner which was not in accordance with law. Yeah. And to seek his extradition, having... I'm sorry if I haven't read it.
Lord Reid's 2 points. Were the sheriff's proceedings invalid proceedings?
The sheriff, when he continued to act in a manner as suggested by the Lord Advocate, was acting in a manner which was infected by the fact of the ultra-vires nature of the submissions made to the Lord Advocate, and he therefore did not have the vires to give them effect. So yes, it was a nullity for what he did, but that does not mean to say if he had done otherwise, in the manner in which I have suggested, the proceedings would have been a nullity, because he could have acted in accordance with the requirements of the law, and recognising in the manner I've suggested the manner in which the Lord Advocate was failing to be in accordance with law.
Now, if you're wanting to leave yourself any meaningful time for a reply, you're going to have to...
Well, 10 minutes is not really meaningful, but on the other hand, there are quite a few matters which I would have liked to have raised. It's a question of whether I raise them now and just keep silent thereafter. And I think, actually, in fairness, I'll raise them now because they're criticism of the Lord Advocate's approach, and I would like to hear what they are, and in fairness to the court. So, and I'll have to deal with that fairly briefly. Paragraph 126, looking at the Lord Advocate's case. Electronic page 126. He says the courts below and the Lord Advocate was required to proceed in accordance with the 2003 Act as was then in force, which in turn required the court under Section 87 to consider whether the appellant's extradition would be compatible with convention rights. Now that's unexceptionable. Where to go off the rails is the next sentence. As part of that process, it was not only appropriate but necessary for the courts below, in the light of the non-commencement of the forum bar provisions having been found to be unlawful, to consider whether the applicant would have been able to avail himself of the benefit of those provisions. So, not only appropriate but necessary. That means there was an obligation on the courts to carry out this hypothetical exercise. What's the source of that obligation? We're not told. On what basis can any authoritative or binding, importantly legally binding judgment on the executive result from that hypothetical exercise? We're not told. The fact that we are dealing with obiter decisions necessarily means that it cannot be binding, and again we have an example of the non-binding nature of obiter observations in the Majesty case, paragraph 36, where this court distinguishes remarks made by Lord Diplock in Hoffman-La Roche as non-binding because they're obiter. Paragraphs 36 to 38, and similarly certain dicta of the Lord Chancellor Lord Irving in the Boddington case. So, how does the Lord Advocate propose that obiter dicta pronounced by a court on a hypothetical basis of what if, had the provisions been enforced, might have been the result? How do they transform into an authoritatively binding decision on the executive and authorising, if found against, the deprivation of liberty and the extradition of the appellant? The Lord Advocate doesn't tell us. As we've already said, it's agreed between the parties at page 59 of the Statement of Facts and Issues, but whereas in the present case the requesting state is the United States of America and the person whose extradition is requested is situation in Scotland, the forum bar provisions may not be relied upon. Now, that's the agreed position, but something, which is why I say look at what they say in the Statement of Facts and Issues and then try and reconcile that with what's said in the case. Because what now seems to be said in the case is that if, having conducted a hypothetical exercise of pretending in the course of extradition proceedings that the forum bar provisions had duly been brought into force, notwithstanding the Lord Advocate's long-stated objections to them, the Sheriff had then reached and expressed the obiter view that the appellant would not have been able successfully to pray and aid the forum bar defence which Parliament had intended that he be able to rely upon, but which the UK Government, on the lobbying of the Scottish Ministers, including the Lord Advocate, had unlawfully deprived him in these extradition proceedings, then the appellant's extradition would not be disproportionate, notwithstanding the declarative unlawfulness which had been pronounced. That's what's being suggested. All those, when you unpack what this exercise is, and it shows just what an abuse of state power is being suggested and was being carried out in this case. This constant suggestion that the issues around lawfulness can be tied up in some kind of proportionality analysis, it comes throughout the Lord Advocate's case, but it's directly contradictory to what they say themselves at paragraph 5E of their case at page 130. But at paragraph D, they say the extradition of the appellant would constitute an interference with his Article 8 rights, which have to be justified if it's in accordance with law and proportionate to that aim, and then says whether an interference is in accordance with law is a prior requirement and a question of law. Only if that requirement is satisfied is it necessary to consider legitimacy of aim and proportionality. That's the position, but then their argument is based on you fold it into somehow a proportionality test because we don't have to take into account the prior unlawfulness. And that's why I have difficulty in this whole case. The salami slicing approach to what is in accordance with law basically is that, is there a basis in law? Yes, we've got the 2003 Act and nobody says that's invalid. Is not the correct approach. We have a defective statutory regime. Apart from anything else, the accordance in law aspect of the Convention is a broader rule of law principle to do with democratic principles and not simply discrete tests as if they were statutorily based. Prejudice is not, individual prejudice is not an issue for establishing whether or not there has an action been in accordance with law, but in any event there is prejudice because the appellant has been made to go through this proceedings, notwithstanding the failure of the Lord Advocate to comply with the law. And this prejudice to the wider community. This is not what should be happening. We rely on the executive to comply with the law and to comply with court orders. Court orders were disregarded, set at naught, and no explanation and no apology has been given from the other side on this. Frankly, that is not good enough. Abuse of process is something which is habile to be taken into account in terms of the oppressive use of these proceedings which were not in accordance with law, and therefore a finding by this court to that effect would be useful and helpful. But anyway, I see I've come to the end of my time. I'll simply conclude with asking this court to uphold this appeal and grant the remedies sought, unless there's other matters I can assist on. That would be it. I would recommend reading very closely the fairly full case which I wrote, because I think it does answer many of the points which were asked of me in argument.
Well, thank you very much, Mr. O'Neill. You've given us plenty to think about over the short adjournment, so we'll adjourn now until 2 o'clock.